Hi guys, glad to see you. Yes, my name is Kamal Tserakhau. I am legal team lead and I am head of the local representative office of Revera, Polska. And we mainly deal with the issues related to the IT sector and game dev, fintech, iGaming issues. We have offices in Poland, Cyprus, Georgia, Belarus, Kazakhstan, and some other locations. So I'll skip an interesting part and switch further. So I will talk about beginnings. So I'll cover some philosophical and idealistic approach. So how the situation is from the legal framework and point of view. After that, I'll give some issues on intellectual property, cover the procedure of app block response legal instruments, and I'll share some case studies that we had last half a year. So a little bit of philosophical and theoretic approach. So now we have two main gatekeepers. Yes, of course, now legislation and there are there's possibility to establish another application store, especially it is emerged in the European Union. But in any case, so we have a gatekeeper. It is a legal term that we can find in the European legislation. And it is some kind of cyberpunk dystopia in which we have two gates and two guardians who are deciding who can be on the market and whose design and value to the market is sufficient to be presented to the users. And it happened due to the two main factors. So first factor is that the market itself is a little bit narrow. So we have only two main markets and they decide who will be in the market, they impose their policies, and at some point the decisions can be even more important than the decision of the court. And the second point, it is a little bit ironically, but it is consequence of the government approach, and they try to regulate this market. As you see, in accordance with the legislative acts of the European Union, like Digital Services Act, Digital Markets Act, Digital Millennium Copyright Act, and other acts, they have imposed additional obligations, many obligations on the main platform holders like Apple and Google, and it's some kind a quasi-judicial function. I would say that I may argue that even obligations are even more than necessary, and we are now in the situation where the gatekeepers decide who will be here and who will be banned. So in accordance with the Digital Services Act, so we can now be acquainted with the main statistics and main reasons, so generally, so what we have. And in Apple, 1.7 million of apps have been rejected. 250,000 of apps have been rejected due to the undocumented features and manipulating with the users. Around 375,000 of apps have been app submissions. App submissions have been rejected due to privacy issues and accumulating data more than was necessary, and problems with the documentation. And around 40,000 app submissions have been rejected due to fraud, and trying to fish data, fish financial information from the users. Moving further. Another situation, so when it is not decided by the platforms themselves, it is takedown notices, and as I have already mentioned, all these acts previously, they impose additional rights and obligation to the platform to block illegal content. And there is a question, so it is quite tricky for the platform. So from the one side, they are interested in that the platform's apps should be on the market and to generate more revenue. From the other side, if there is some violation or infringement, they will be also punished. They will be liable if they will not act properly in accordance with the procedure established. And in accordance with the statistics, thanks to the Digital Services Act, so as you can see, 3 to 4 notices, takedown notices have been submitted based on the intellectual property issues, so like copying or mimicking, using someone's materials like preloads, ads, 3D models, and others. So as like big parts is violating of the privacy and illegal services. Some kind of issues or features of the app can be considered as illegal in some locations. So we are conducting mainly for the like proactive protection strategy, because it is at the start or before publishing the app, because it is more efficient to prevent the ban than to further try to cure it by the communication with the platforms. So first of all, it is important to assess the competitive landscape. So who is on the market, so like similar apps, so they copyrighted materials, they trademark materials, because more likely they will be the submitters of the complaints against you. You will be forced to deal with them. And in our practice, it happened actually that it was not only the problem of, so the problem may arise not only in the like our market of apps, but also in the real economy. So for example, we had a case where middle-sized game dev company had a problem with German factory producing physical toys. So yes, physical toys that you can buy in the shop for your children, because they had a trademark with the identical name, and they had a software that were used like to customize in this toy. And it actually took maybe several months to deal with all complaints they have submitted and the letter of claims. But fortunately, finally, we have dealt and decided the case in favor. Other issue is platform-specific and legal compliance review. So if especially you are dealing with the highly risked spheres, so like gambling, fintech, or you have some kind of specific features for example, multi-level monetization issues. So you need to analyze whether it can be compatible with the local laws, because it can be as a ground for rejection of the app or other problems with the clients. Also analysis of the policy requirements and especially design and feature issues for the small apps, for the startups. There's actually a big problem with the copycat that arises like immediately upon the publishing of the app. After that, usually you need to analyze at weekly base the app that is similar to the name or maybe like style with your app. So there can be some copying of it. We even faced the situation when they just write it the preloads using it's the same actually material, and so usually it is from Asian market. They have appeared just about maybe 3 days upon the successful submission of the app. So in that case, of course, you'll need to respond effectively and very fast, because they can be like uploading a lot of advertising to and attract your own users from it. So here actually you can scan and see our small quiz IP game. I also provide a disclaimer that we will not transfer Eurobucks that you will won upon completion of this quiz. So actually where the issues may usually, so whom are main submitters of the notices and whom you may have a problem. First of all, of course, it is competitors and big publishers, especially if you are trying like to mimicking some well-known brand or well-known game. In that situation, you need somehow to have a safe distance from them. Platforms, their procedures are quite, I would say, straightforward. So if you are just, for example, taking some game and you are using, say, like an idea to proceed to promote your game, it should be only limited to the idea. You should not use the materials, graphic identical. You should not copy like the masks or models or something like that. Because if there is a precise copying or very similar copying, the more likely that your app will be struck out from the app. Out of platform, out of store owners, IP holders, for example, like music, or there can be also issues with the phones. So if you found some material, for example, bad known or known only on the local market musician, it could be also a problem. If you use it without the proper license, it can lead to the takedown notice and striking out of your app. Also, followers and copycat publishers, you need to analyze over the market and see maybe someone is copying you, trying to use it. And trolls. So trolls actually is a big problem, but we'll deal with it a little bit later. So how the process is going? So takedown notice is when received by the platform like Google or Apple. They do not usually decide at the same moment. And these practices, they differ. So if it is Apple, usually it makes an email thread and sends it further to the holder of the account and proposes to negotiate the issues and maybe to delete some like infringing material. And this is good because you may like either to persuade the other parties that it is like illegal to submit this complaint, because sometimes it happens, and in accordance with the Digital Millennium Copyright Act, it is punishable to submit unfounded notices, takedown notices. Google usually makes, usually asks the takedown notice submitter, so some details. It requires some comparative, for example, materials. In that situation, you need to be precise. So you cannot just say that it is like copying of our game. So there should be precise, like screenshots from the games, maybe even by pointing out that this exact material has been copied. Because sometimes we are receiving requests from our client like they have copied our idea, or the feeling of the game is similar. So actually the feeling is not protected. You cannot just check out your competitor's app just because the game is felt like your game. So there should be actually, so this text or this like 3D model or something, or music has been copied. So after that, the platform decides what to do. So Google just check out. Apple will do it usually in the most cases if there is no like a connection between the parties, or the account holder is silent for a long time. After that, in accordance with the Digital Millennium Copyright Act, the account holder may submit a content notification for unblocking. In this situation, the app will stay blocked for 10 to 14 working days. And if the holder of the IP have not submitted a claim, it will be unblocked. And otherwise, so the block will stay and until the litigation will end between the parties. So in accordance with the Digital Millennium Copyright Act in the US, it should be jurisdiction of the US courts, but in fact, it is possible to submit the claim in other courts, in other locations, and it may suffice to block stay. Trolls. Actually, I would say that there is no good strategy how to deal with the trolls. So what do they do? It is a term. It is not just like a funny situation. They monitor viral content and register in the US copyright or trademark, and after that they are beginning to attack, especially the companies which has like a weak IP protection on this matter. So the first step is usually demanding payments under some kind of license agreement, and upon refusal they'll file takedown notices. And unfortunately, procedure is flawed. We faced in a situation where the trolls were submitting complaints and takedown notices and claiming that they were They have forged corporate documents. They have forged power of attorney to present that they represent us, so our client, represent our client, and we are blocking our own app. Even that situation has been. So what to do? It depends. It's like your decision what to do. Both parts are hard. So if you agree to pay, so the situation may be resolved. So you're like a person who can be milked again if they decide to. So if they will be hungry, they may just milk you again. If you refuse to pay, you may face a long-standing dispute and problems, and it will be very hard to deal with Google and Apple on this issue. It could be a claim, even litigation, so it's you to decide. What to do? So first of all, most of the cases have been resolved through the support. So there is no magic. So I would say straightforward. There is no magic. So there is no some pills that you can use and your app will never be blocked. So it is no such. But from our practice, most of the cases have been resolved from the support. It is important to receive more information. It can be hard, of course, based on the emails that you receive from the platform. But try to understand, so what is the main problem, to deal with it. It can be effective also to design some kind of plan, like a step plan, action plan, so how will you deal with the problem. And if your violation of the policies is not so severe, it can help and your app can be unblocked now, like in advance. You can also submit a formal appeal, but it is effective only in the situations where there is a mistake. In accordance with the Digital Services Act, the plus of this procedure that it should be always reviewed by the person, not by the automated means. But in most cases, it is not very effective. In addition, you may submit a transparency request. It is a new instrument provided by the Digital Services Act. In this situation, platforms is obliged to provide the reasoning standing behind the decision, because it is always a problem to to understand so what is the problem. So there's sometimes just a reference to some clause of the policies, and you do not understand so what exactly is the problem in your app. In this situation, we'll understand what to do. And also out-of-court dispute resolution, it is also provided by the European legislation, but it is useless. We have used it 3 times immediately upon its establishment. It was not connected with the apps, but it is like example of the effectiveness. We filed against Google, Meta, and LinkedIn. And actually nothing happened because they have not even presented their position in this case. Because the decision of the body who decides these cases is non-obligatory for the platform. So it's like they view, so is it, had the problem dealt with the situation correctly or not? So that's all. So who judges the judges? So what is possible to do out of the platform and its procedures? I would say that firstly, it would be better to deal with the platform. It would be faster. So in our practice, it is usually possible to settle this situation for about 1 month. But like a last resort, you can use regulatory means and regulatory approach in this issue. It will take a lot of time, a lot of money, but you can use it. So you can submit complaints to antitrust authorities, to Digital Millennium Act authorities, and to local Digital Services Act authorities located in the member state where your company is. So I have provided for the Cyprus, where the main headquarters usually located. And it is a little bit funny, but Poland has not yet appointed its coordinator, at least for the moment I have prepared this presentation. And sometimes we receive like requests, so we will use Google, we will file a claim against Apple, why not? But unfortunately, it is a very bad idea, so it will cost much, but it is possible, so why not? So we can file a formal claim, and maybe something happens from it, but it will cost. So it should be some kind of very great situation, great revenue threatened to be lost, so to use such an option. So some our cases from the last half a year. First relates to the multi-level referral program. The client had a board application with implemented multi-level referral system. So when the user invites the user, he will receive some part of the bonus that attracted user generates. And so there was a main feature, of course. There was a lot of other features. It was not the main with referral system, but it existed. And Apple refused to admit the submission. After some communications, we received the information that they decided that this is something like a pyramid system that is forbidden, pyramid scheme. So the situation has been resolved only after amendment of the system, and we were forced to flatten it, to decrease the amounts of bonuses, and after that the app had been submitted to the store. And to present some like case with related to the takedown notices, we had a long-term battle against a AAA publisher who decided that the game of our client is like mimicking and taking users from that company. But hopefully there was no direct copying any material. So of course, when you played the game, it was like so you understand by which game the developers were inspired, but they were inspired. It is not prohibited to be inspired. It is prohibited to copy. AAA publisher tried to strike out by notices, by claims. They also submitted oppositions against our trademark registration. But finally, the situation has been resolved, and app was never blocked. So it gains its users and players, and everything have ended in the settlement agreement with the publisher, and they promised not to sue us again. I hope so. Thank you for the attention. This QR code.
Thank you very much.